We'll move now to the confirmation of the minutes of the meeting held on Thursday, September 15, 2022. Apologies. Before we go into the confirmation of the meeting of the minutes, may I ask for a word of prayer?
Let
Member
us
Hamilton?
pray.
Okay, Member Gale.
Most righteous and heavenly Father, again we meet to do our proceedings for very important legislation. And we ask and invite your presence, although we know you are always here with us. We ask for your guidance to take us through to understand greater. These we ask in your merciful name. Amen.
Thank you, Member Gale. We'll move to the confirmation of the minutes of the meeting held on Thursday, September 15, 2022. And we will start with page 1. Page 2. Page 3. All right, we're going to double check in terms of technical assistance so we can hear our members online and they can hear us. All right, we'll try again. Are you hearing us, members online?
Yes. We're hearing this far better now. Are you hearing us?
Great, we're hearing you as well, loud and clear in that baritone voice.
All right. Are you also hearing me?
Thank you,
Minister?
Madam Chair.
Yes, Member Rodriguez.
Okay, thank you.
Hearing you, and please remember to turn on your cameras if you are going to speak. All right, we'll continue with the confirmation of the minutes. I think we were on page 3. I have a correction in the last paragraph where it starts with Senator Gale. Didn't quite understand where it says Senator Brown questioned the protection of stakeholders. If everyone was not consulted, was that the right word, the protection of stakeholders?
It may have been, Chair, what he said, in that you want to be assured that stakeholders' views were brought to the table. And in the event that stakeholders would have had any concerns, then such concerns would have been protected. His term. But in my understanding of it, it may have been getting this, ensuring that we capture the stakeholders' concerns.
All right, thank you, member. Page 4, I have just a small, teeny tiny edit. In the very first paragraph, line number 4, if we start from where it says at the top, she noted that the insertion would read, there's just an extraneous T. On page 4, the first paragraph, line 4, there's an extraneous T. Inspection would read, you see that, Member Gale? Okay, welcome, Member Brown. All right, page 5. Page 6. Page 7. Page 8. Page 9. Page 10. Do I hear confirmation of the minutes?
Yeah, I so move, Chair.
Moved by Member
Second.
Gale, seconded by Member Hamilton. All right, matters for discussion. Continuation of the review of the matrix of submissions. And where we are currently, we will be starting on page 13, section 24. Prohibition against practicing as a teacher without being registered and licensed or authorized. And as usual, we'll move across the page. So what we need to consider, just a reminder from our technical persons, that we need to insert a provision to cater for penalizing employer if the employer employs a teacher without license at section 24. So the new 24.2, also new 24.4 to include penalty for employer. And then there's the issue of whether or not we raise the fine on the section 25 and 26 to 1 million and imprisonment to 12 months. I think there were submissions, at least from one group that I remember, but we will go through the matrix.
Just to clarify, Chair, with the insertion now. Oh, the employer would be captured in 24.2. Is it that? No, it says 24.4.
New 24.4.
New 24.4.
All right. All right. So let's work through all the submissions that came in, because I believe it was, well, there was, the Jamaica Teachers Association was the entity that pointed out that this version of the bill has failed to penalize an employer from hiring or engaging the services of a person who is not a registered and/or licensed teacher or instructor, and it is their view that this should be included. But let's go back to Mr. Douglas with regards to his recommendation. He said, as it relates to section 24.2, I would therefore suggest that the hefty fine of, that should be 500,000, right? 500,000 Jamaican dollars for fraudulently teaching without a license be reconsidered, as truly the current learning loss dilemma cannot afford for learned population who can assist to be repelled from offering assistance. Let this be substituted for a program which can sensitize and certify that those who wish to offer assistance as para-tutors or teachers' aid based on the prerequisites outlined by the Council and thus promote their activities, whilst it is regulated by an assigned head teacher. And I do believe, and our technical persons can correct me, that in this we make provision, we exclude persons who are teachers' aid, right? Ms. Shoreland, I remember reading that it would not apply to persons who are teaching aid. Is that correct? When you look at the definition of a teacher,
Yes, Minister. If we look at the definition of teach, we had it excluded a teacher's aid. So teach means to undertake duties in any educational setting to which this act applies. And we said that include A1 to, but does not include duties of the kind undertaken by one, a teacher's aide or a teacher's assistant in the care of students or the supervision of their work under the direction of a licensed teacher or a person who has been granted an authorization to teach under this act.
Right. But the only, well, it deals with teachers' aides, but what about the para-tutors? Is that a different terminology?
Based on last week's discussion, we would have spoken about the paraprofessionals. So would this include the paraprofessionals too? Yes or no?
One person is saying yes, and one person
saying
saying
yes,
no.
and one person saying no. So maybe Mrs. Gordon-Jones, you can be the tiebreaker.
Let's hear from both. as to why you say no and why one other person said yes? Or you want to talk amongst yourselves and have one position? Okay.
Robert, are you hearing? Because I've lost sound.
Oh, we're not saying anything.
Not clear. We're not
I
saying
don't
no.
think they're
The
speaking.
our legal
legal team
our
is
legal
discussing
team
the matter.
our legal team is conferring with each other.
Yes.
Oh, okay. Thanks.
Yeah. And it relates to the meaning of the words para-tutors. The question from Member Gale was whether or not that is considered under the term paraprofessionals.
Okay. I took it as such, but that could just be me.
Chair,
Go ahead, member.
I remember on the last occasion I was asking whether or not we should have a definition for the term. I think this is a perfect time to probably consider it because if we are having a challenge now determining what is covered, then if the legislation goes as is without a definition, we'll have a problem in the future. My opinion.
I agree, member. Go ahead, Member Brown. Member Brown, we're going to ask you to repeat so that we get you on record.
Why you just sit here, man?
Essentially, I'm saying at 24.1 on page 25, there, a person shall not practice as a teacher. The word practice is used. I am not sure that practice, let me just double check, that practice is defined, but there's a definition of teach. And so, yes, practice as a teacher includes the provision of services. So there's practice there. So the concern I have is whether or not we want to be consistent with the language, teach versus practice as a teacher, and whether or not educational institutions as that the law applies to, whether that includes home setting. I'm going to move.
You mean educational setting?
Yes,
yeah.
Whether it's broad enough to apply to homes.
Chair, I'm not sure I'm clear on Senator Brown's question just now, or observation. Senator, are you saying that there needs to be a definition for the verb practice?
Or MP Hamilton. Sorry, but I agree with him. Instead of saying practice, you could just say teach.
That's where
because then the language would be consistent.
I still don't get it. What's the issue?
The issue is if you bring in a different language.
Teach is defined in the legislation, whereas practice isn't. Yeah. Actually, remember, there is a definition, practice as a teacher. If you look in the definition on page 5, practice as a teacher is there in section 4, yeah.
Sorry, where's that
interpretation,
definition?
practice, yes.
Remember, if you look at page 5.
Mm-hmm.
Okay, thanks.
Member Hamilton, does that clarify your question?
Yes, sure it does.
So we leave that word practice there. Member Brown? All right.
I mean, could we just remove this definition? Practice as a teacher? Is it really that relevant? I'm not sure, because including a definition for that obviously is a cause for concern. Do we need to define what practice as a teacher is if we have a definition already for teacher and teach? I thought it was just a regular use of the term practice. I never knew it had a special connotation.
Which suggests the action itself.
Why can't we just say teach instead of saying the practice any at all?
You could still use the term practice as a teacher without having a definition for it, because that would be the ordinary dictionary meaning.
True.
I already have a definition of teach in the document.
You want to come on microphone and say that? Yeah.
I was just repeating, Chair, that we really don't need a definition for practice as a teacher. Because, I think we are kind of creating layers of issues When we have a definition for teacher, we have a definition for teach, and then we're going to have a definition for practice as a teacher, which shouldn't be different from the other two definitions.
And through your chair, Member Hamilton, it's connected to clause 4. So you may want to look to see if we can get some consistency in language. This is what we've been proposing. And I just want to point out that at 4E, it addresses approved home education. What if the home education is not approved? Does this teach or practice as a teacher become null relative to that, given that's how it's defined in the law? And just asking for consistency and clarification.
Ms. Sherlin, there are a number of questions. Dr. Gordon, Ms. Anastasia. So one of the questions is, should we continue to keep this definition, practice as a teacher? If that is removed, will it do harm to the bill?
I'm through you, Chair. I'm not proposing the removal yet. I just want some thought into the consistency to make sure it's all consistent. And for example, as I said, 4E, which is where practice as a teacher apply. If the home is not approved, is there an offense? Maybe under some other section, but if somebody is practicing or is teaching in an unapproved home program, are we capturing that scenario? Or, yeah, let me pause there.
I see where the practice of teaching is also in section 6G. The last 6G, the last one. Page 9. Oh. No, I think we had changed that to read the practice of the teaching profession. I don't know. We'll leave it up to the legal minds. Are you ready, Ms. Charlotte? Are you ready?
Minister, could you please repeat the point or the issue that has been raised? Thanks.
All right. Member Hamilton is asking if I think it's Member Hamilton and Member Brown, do we need this definition, practice as a teacher, when we already define teach? That's one question. Should we Member Brown has a different question that relates
it's
to
much the same, Minister. It's about the consistency in the language.
Home education. What if it's not an approved home education? And then there was another observation about education setting. If you read in the definition of teach, teach means to undertake duties in any educational setting. I thought that we had, instead of using educational setting, I thought we had educational institution. I'm trying to find it because it was, yeah, it is defined. Educational institution is defined. So is it that educational setting and educational institution are the same? So I think there are 4 different issues.
Yes, Minister. In relation to practice as a teacher, it is used 11 times in the bill. So we'd have to go through to determine whether it is wise to remove the definition. How would that affect one's interpretation of the different provisions in which the term is used?
Or you could, in addition to that, Ms. Sherland, determine if we could, the replacing or the use of the term teach can apply in those particular areas.
Through your chair, it's a search of consistency in language. Because if we use a set of phrase one place, another phrase another place, it's open the courts to say you didn't mean the same thing, as you are well aware.
Chair. I have another question, or I need some clarity in terms of the use of the word practice. So initially when I read 24:1 and it said, a person shall not practice as a teacher, I thought it was the verb practice, but then it's the ICE, which is the noun practice. So what are we trying to, are we saying that practice as a teacher is a noun? Is that what it is? Because I thought to practice in this particular sentence, I interpreted it to be a verb. And I think that would make a difference. But then the use of the practice with the C here would make it a noun. So I am a bit confused which one we're actually trying to capture in this particular section.
For those online, our legal team is conferring.
Thanks for the update, Minister. Appreciate it.
Madam Chairman, through you,
Yes, please go ahead.
Just
Yeah.
to, as the member rightly indicated, it should really be S, not C. And also Dr. Gordon was indicating that practice to teach, practice as a teacher is a term of art. However, teach could be substituted therefore. And if we do that, well, we'd have to look at all the provisions where practice as a teacher is used and make sure that it is accurate if we change those words to say teach.
Which is Senator Gale's point to your minister, that you look back at the 11 and advise. That would be my recommendation, Minister, that they look
All
back
right.
and see.
So
We're not
the
opposing to
legal
Senator.
team will look back at the 11 times that practice as a teacher is used to see if it can be substituted for the word teach, which has a very precise definition. So that takes care of practice as a teacher and teach. So we'll allow the legal team to do that.
Just to be clear, the ISE suggests that you are practicing. Now, when you practice at something, it means that you always want to repeatedly practice or repeatedly do it to improve your skill. This assumes that they are already teachers and that you're not practicing to attain to the level of a teacher by using the ISE. No,
What
the
should we be
ISE
using?
is when you practice. No, you practice like a footballer
An
would be
attorney's
practicing
practice
to improve their
An
skill.
attorney's practice is the ICE.
Is the ICE.
Right.
Right.
Right. So the ISE is the verb.
Is the verb.
Yes.
Right. So the ISE can't be used here. But you're already a teacher, you're not practicing to be.
In the profession, there's something called a teacher practitioner, a teacher in practice. There's a transition from teachers' college into the schools, which is a practice.
What do you call that, Dr. Gordon? Practicing teacher?
Yes, Minister, we call them practicing teachers. And the term practice to teach, it's a terminology in the profession. Or practice teaching, practice to teach. You cannot carry out the practice of teaching. It's a common terminology in the profession. So,
It's confused with practice teacher, right?
what happened is that in the whole development of the bill and the discussion, the emphasis was always on the practice. You must not practice this profession unless you are licensed to do so.
All right, so are we any clearer on this matter? Is there clarity on this matter? I know where we're leaving it is that our legal team will take a look at practice as a teacher and compare that with the definition that we have of teach to see the alignment or lack thereof and to make any corrections that are needed.
Minister.
Yes, member.
Just a quick, even Google search as to the international standard. And it shows that if you use the C, practice with a C, it's talking about teaching practice, which is where the teachers go off on sort of an internship or, when they go to the classroom before they graduate. So if it's with an S, then it would be applicable in this case. But if it's with a C, it's specifically on a global scale refers to the internship that teachers do.
Thank you, Member Rodriguez. So where we're leaving this is that the legal team will look at practice as a teacher with the S to see if it should be a C. If it's determined that that should remain, they will also look at practice as a teacher compared with the word that's defined, teach, to see if that could be, if teach could be used throughout the bill rather than practice as a teacher. So we'll leave that with them. There's at least 3 other ones that we need to clear up before we move ahead. The next one is educational setting, and that Member Brown brought up. And I wanted to point out that in the bill, we do have a definition for educational institution, but not setting. So what are we talking about when we speak to in any educational setting? Because it's saying teach means to undertake duties in any educational setting to which this act applies. Right. Setting seems broader. Mm-hmm. Again, for those online, we're waiting on our legal team as they look at educational setting versus educational institution. All right, legal team, is this something we have to leave with you then for consideration?
Yes, Minister, because if you define, you have to be careful how you define educational setting, because you don't want to, for it to be too limited. So perhaps you could say includes, and then you name some possible settings, so that you don't box yourself in, so to speak. Because Doc was mentioning that especially now with virtual learning, that in itself is a space, is a setting. And even to come up with words to define educational setting, it may be a challenge. So it's really something to think about.
Mike? Okay.
Yeah, just that clause 4, in a sense, what we're looking at is clause 4 here, which says where it applies to, where this act applies to, and also section 2 of the Education Act, where institution, is that what it is? Educational institutions are defined. So how do we merge institution and our setting? Yeah.
Well, Member Brown, because a setting, as you can appreciate, is not necessarily an institution. That is where the challenge is.
So which is why
what is a setting?
Look how we merge them, how we combine both under, is what I said, under institution, under setting. So do we merge them, and do we leave setting to be so broad, to be unenforceable? I'm not so much calling for a restriction, but I want it to be clear that guidance is there as to what is a setting. And at clause 4, part of that setting now includes approved scheme. What of, as you say, what if it's a virtual situation? So how do we capture those? Otherwise, there's loopholes that people will just ride through.
So, Member Brown, are you suggesting, sorry, Minister, through you, that wherever we use public educational institution, perhaps we should consider in that same provision to make reference to an educational setting?
I await your guidance on whether or not that's a feasible approach.
But is it, Member Brown, just to ask a question, is it that educational setting is too broad, will cover too wide a net, will cover too wide an area?
I'm applying setting, Chair, Minister, to clause 4. This act applies to, because it says, I believe the definition was relative to clause 4. And it leaves some leeway that this is not, anything else is not part of the setting, and anything outside that is not part of the setting, since the setting is defined at 1A to J. Yeah. So it's about finding the language, appropriate language that captures 4, what is that 4, and what is in the Education Act that define institutions. It's not one or the other, so do you get them together?
Madam Chair, may I?
Please go ahead.
Yes. In an education setting, we can have 3 settings. There's the formal education, non-formal and informal, and they're all described as educational settings. So we would have appealed for some time to discuss that aspect of it, to see what terminology we should use, because we cannot leave education setting hanging.
I'm sorry, you cannot.
So we need some time to study the terminology.
All right, but you said there were 3 different settings, formal, informal, and what's the other one?
Non-formal.
Non-formal, okay. Informal, yeah. So formal is like when you go to school? Informal is kind of like what we're doing here?
By the way, education. And non-formal.
And non-formal is like you're a part of a group, like
the
cadets or the, yeah.
Minister,
Yes,
where would
member.
homeschooling fall under those three categories? Where would homeschooling fall?
I would say, based on the presentations from the homeschoolers, it sounds like it's a formal setting to me, because you have a prescribed program. Yes, they may also engage in other settings from time to time, which all our children do, right? They go to
I would
school,
agree
it's
with
in a
you.
formal setting. When they go home, it's informal. Learning is taking place there. If they're a member of a club, there's non-formal learning that's taking place there as well. I don't know if that answers the question.
And 4E, 4.1E
Yes, it does, Minister.
addresses the homeschool. Just that it's require approval from the ministry. And I'm just wondering if that's sufficient.
Right, you had asked the question, Member Brown, what if it's not approved?
Chair, I think we should perhaps wait on the technocrats to define the three terms, and then after that is done, then we can decide where which falls based on those definitions, despite our knowledge of what homeschooling and other settings usually mean or require.
Right, I agree, Member, and the fact that we've spent so much time on it means that it's worthy of greater clarification. So we will leave that as well with our legal team, but also there are, let's see, there's the other issue of the para-tutor, whether or not that's the same as paraprofessional. So we'll leave that with you as well. We'll leave that with the technical team. All right, so in terms of Mr. Douglas's submission, we would have adequately dealt with his concerns about teachers' aides, because they're not included under this bill. But then we have the issue of para-tutors. All right, we'll move on to the next column entitled Jamaica Teachers Association, and their recommendations are as follows. It says, whereas we understand the rationale of deterrence, the fines of up to $500,000 are too harsh and excessive. At the very least, teaching without a license or pretending to have a license should not be treated equally with this situation where a person acts fraudulently or is found to have made a misrepresentation as it is proposed in the bill. And they give an example of the Spirit License Act that has different levels of penalties. So let's take that one.
Chair, I agree with that recommendation.
Sorry, Member Crawford, can you come on video? Can you turn on your camera? And could you say exactly what you're agreeing with? Member Crawford?
Are you seeing me?
Yes, we are now.
Yes. No, so I was saying that I agree with the recommendation that the fraudulent, someone whose license would have expired, should be treated differently from someone who deliberately commits a fraud, who deliberately set out to deceive. rather than someone whose license would have expired or so.
Okay, so you're in agreement with a tiered system then?
Yes, I'm in agreement with a tiered system.
So you have two situations here. You have in the first instance where that teacher's license would have been expired, and there would have been a gap now in practicing, because you can't practice with an expired license.
You can't practice, you're not supposed to.
You're not supposed to, thank you. You're not supposed to practice with an expired license. But is it a situation where you have no control over the acquiring of the new license? Let's say there were administrative maladies that would have caused you not to receive the new license. What this is suggesting is that it's suggesting the exposure to the highest penalty, as opposed to the individual who would have been practicing knowingly and intently not having a license. Now that is more egregious in nature than the individual by cause would have been, for whatever reason, have not received the license. So there ought to be a separation in terms of the treatment. And I'm not even using the term penalty. A separation of the treatment in the first instance. We can determine the extent of the action later on. But we have to distinctly decide how they are treated, because it's two different exposures at two different levels.
What, Chair?
Go ahead, Member Hampton.
I in principle agree with identifying tiers. But Senator Gale just mentioned something a while ago and something came to me. So you have someone who has applied for renewal. That person has applied within the time frame that is stipulated, but for whatever reason, from the council, there's an administrative issue that prevents the license from being issued within the required time. Now that would be no fault at all on the teacher, of the teacher. In a situation like that, there could be no contemplation of a penalty. So we would have to therefore indicate that it would have to be someone who has not applied within a particular time, or the particular time stipulated within the legislation. Say you're supposed to do the new renewal 3 months before it expires, for example, and you do it a month after the expiration. But do we really want to fine somebody $500,000, for example, for applying a month after it has expired? So it raises a lot of concerns. So I'm not sure how we deal with that, but we would have to also contemplate those situations.
But if we have the tiers and we have a different fine associated or different penalties, I think that would address that concern that you have.
Through you, Chair.
Go ahead, Member Brown.
I understand Member Crawford to be saying that there are different offenses. There's a bandulo who comes in and wants to teach, never went to teachers' college, had no qualification. That's one person who must be dealt with differently from somebody who went through teachers' college and through inadvertence, the holiday license up 31st December, it's the holiday, Christmas, school open back in January, to be treated differently. And so I share the view that we should have two different offenses here. One for those who, deception, I think that's the word he used, and one where there's inadvertence, without necessarily using language. Right? And therefore the penalties are different. And so the suggestion from the JTA, supported by Member Crawford, of the approach adopted in the Spirit License Act is the one I support. And then we can decide what the figure upper limit should be as to what the penalty would be. But the principle is that you shouldn't treat the bandulo and a bona fide teacher in the same manner.
All right. Member Green, I know in the last discussion, when submissions were being made, I don't know if Member Green is on. Yeah, when submissions were made, you had some comments at the time. Do you want to repeat them? Do you have any further thoughts on this?
No, not yet, Minister. You would have to give me a few moments to pull that up.
All right, thanks.
Sure.
But in principle, I think we agree to the tiering.
I agree with tiering, but I must also add that I don't think a teacher who has not applied for their license within the time frame stipulated should be subject to an offense. If we want to, administratively say, if you don't apply within the time, then we will double the application fee or, something of that nature. But not to say the person has committed an offense, because I think that is really excessive. So when we're thinking of tiering it, we would have to now extract that particular scenario and remove it from 24(2). So it's no longer an offense if you don't apply on time. And then you could put a figure, I don't know. I'll leave that to the professionals.
Right, so that's in line with, I think, what my other members are saying about looking at the different categories.
Yes, Chair, I understand that, but what I'm saying is, in this situation, it says it's an offense. We have not dealt with the offense aspect of it. We don't want to criminalize somebody because they have not applied for a license on time. It's not just the fine, no, that we're talking about, or the penalty. We're talking about it says a person who contravenes subsection 1 commits an offense and is liable on summary conviction in a parish court to a fine not exceeding. You don't want somebody's record to have that they are now a criminal because they didn't apply for a license.
Right. All right.
Agreed,
so the
Madam
first
Chair,
order
if I
of
may.
business is to have different categories. The second order is to look at this kind of one size fits all offense.
Right, to disaggregate.
Yeah.
Right.
Yeah. Disaggregate what that means. If you are a bona fide teacher, you are licensed, you forgot to renew your license for whatever the case is. As you said, should it be that the application fee, or whatever fees you're paying, are double, triple, or whatever the situation is, versus someone who is just fraudulent?
Here, I also want us to take into consideration what is being contemplated by the new 24(4). That gives the obligation now on an employer.
Member, before you go there, let's finish.
I'm not going to that yet. I'm just suggesting that in treating with the penalties, we must bear in mind that the employer too may have an obligation to treat with.
Okay. All right, I'd love to hear from Dr. Gordon on this point. First, the tiering, well, the different segmenting, the different types of outcomes that we could get. I think we all agree that if somebody is just fraudulent, then they should get the highest penalty. If somebody's just fraudulent about it, should be, the maximum penalty, right? I think we all agree on that. Right. Mm-hmm.
Good afternoon, Chair.
Go ahead, yes.
Member. When we had our discussions in terms of the fines and based on the submissions of the different stakeholders, we had proposed, and we were in agreement with the tiered approach. However, we were thinking of keeping the 500,000 for clause 24 and raising 25 and 26 to $1 million instead. So that was our suggestion.
Recommended by the parents.
And based on the fact that it was recommended by the parents for it to be raised to 2.5 million.
Chair, I don't know if I agree with that $1 million. Fine.
I don't think that $1 million.
The $1 million would be for the fraudulent person. Right?
No,
They're
why
not a registered teacher, they're not a licensed teacher or an instructor, but they claim to be a registered teacher, a licensed teacher, or an instructor. That $1 million would be for that situation, the fraudulent situation.
But why not keep the maximum at 500,000 and the other fines are less severe than that?
Member Crawford, it's only because if somebody how did you put it, Member Gale? If they are just deliberate,
Bandulo.
if they're bandula,
knowingly and intently promoting a fraudulent action.
We should have no mercy on that person.
Mercy say no.
Sorry, Member Miller, what do you say?
I'm in full agreement, Madam Chair. I said mercy say no.
Okay, for somebody who's deliberate, who's a bandulu, yeah.
Chair, may I remind
But I'd like to add to the point that Member Hamilton was discussing earlier, Madam Chair, if I may.
Go ahead, Member Miller.
Is it a situation where persons will be given grace period to be registered? But I'm in full agreement with what Member Hamilton stated earlier in terms of if a person failed to register at a particular time. Renew. Sorry, my bad. Renew, my bad. I stand corrected. Renew at a particular point that, grace should be given up to a certain point. Maybe it could be additional penalties, like $1,000 per day when a person is not registered or something, but I don't believe that we should criminalize a person within a specific period of time after renewal if that person is not renewed.
Chair, what I understand Member Hamilton to be saying, supported by Member Miller, is that in respect to the renewal of license, that an administrative rather than a judicial approach be adopted. Maybe in the first instance. So if it's not done within a year, then it may, and you continue to teach, and I just pull a year out of the year. So maybe an administrative approach could be adopted there, and we could determine what would be the course of that administrative approach.
what we're trying to determine here, so we have already made a distinction about the person who is fraudulent and how they would be treated in that minefield over there. So we're now speaking about the person who is already a registered teacher. The license would have expired and they would have failed to renew. And that failure to renew should attract a different penalty, but not to the extent of a conviction or an amount so excessive, but more of an administrative penalty. So you have failed. It could have been, one of the reasons for the failure is that even the application of the process, Ian would have come to Jamaica, and whatever the cause may be, you could not have. There are circumstances that could have caused a teacher not to have met the requirement of a renewal date. And we are saying that that teacher ought not to be treated in this excessive manner.
As a criminal.
As a criminal. Because it's not a criminal act. It might be an act of, a failure on the part of the teacher. And the penalty should be different.
So, Chair, a couple of things, and hopefully you can hear me.
Minister Green, is it possible for you to be on camera? Member Green?
Yeah, let me organize that. Sorry, hopefully you can hear me clearly.
Black River.
Yes, I am in transit. All right, so firstly, there are some things that you can legislate for. There are some things that are administrative. And I think that is where part of the discussion, we lose part of the discussion. My reading of the section is that section 24 indicates that if you are not a licensed teacher, you are not to be, let me just ensure that a person shall not practice as a teacher unless the person is licensed to teach and the person is an instructor, right? And if you are not licensed to teach or you are not an instructor, then you are in contravention of the section, right? Which I think is standard based on the scheme of the act. In other words, we are saying that people who are to teach have to be licensed, and we believe that for somebody to be in the classroom and not licensed to teach would have committed a criminal offense. Now, if administratively the council puts in place that your license is still valid 1 month after the expiry date, because in that period is the due time for you to do all the preparations. Clearly those things will be administrative. But once you do not have a license, then you are unable to practice as a teacher. I'm not sure we can try to, in the legislation, account for different scenarios that would have people not be in possession of a license. If you do not renew your legal certification, you are not to be in court practicing. You are not to practice as a lawyer. It's black and white. There's no, so if you were abroad and you couldn't renew it, you can't practice until you can renew it. Right? So I'm not sure we can find a sort of mid-ground in the legislation. I believe you can find mid-grounds in an administrative process. But I think the legislation may have to be clear that if you practice without a license, there's a criminal offense. And this is the fine. And I do support the tiered approach. So I do believe that once you input something like fraud, then it is a higher penalty than if you are just without a license. to practice. But I'm not sure we can make any changes to Section 24.1 and Section 24.2 that brings forward the offense. I'm not sure we can take a middle of the road approach.
All right, go ahead, Member Gale.
Member Green, I want to ask you a question. Are you saying to us that tomorrow, Friday, my license would have expired, and so I cannot practice on Monday? Are you saying that I should not be practicing on Monday?
So I'm saying a couple of things. If you know your license is going to expire on Friday, then you should have started the process to renew your license so that you have a license to practice on Monday. So, if your driver's license expires and you failed to go and renew your driver's license, knowing very well that on your birthday your license would expire, right? When the police stops you, there is no grace period in relation to your driver's license, as opposed to other things that there's a grace period. But if your license expires, you can't say, boy, I was in the country, etc., etc. Provisions must be put in place so that you do not have to be without a license. No, administrative processes can be put in if it's that. So, for example, one would expect that you are able to apply for a new license long before your license expires, so that you are never out of a license. Again, lawyers have to get their legal certificate every year. So you can't the day after go into a matter and say, boy, your license, your certificate just expired, right? You would have to put things in place to ensure that when you go, you have your certificate.
I agree with Member Green because it's the same thing with a firearm license. You know when it's going to expire, you have to get it renewed before, because if your license expires on Monday and you are caught, a police stop you and your license has expired, it doesn't matter if you have that 5-year license. If you don't have the one that you have to renew annually, and if it is a day over, you're still going to be charged for illegal possession of firearm.
15 years. 15
years, yeah. There's two things here, and Chair, I'm sorry to belaboring the point, but I want a distinction in my mind. You cease to practice, so you can't come to school and go into the classroom the Monday morning because you don't have your license. But are you still exposed to a penalty? So you have to get the license in which to practice based on what this is saying. But is a double whammy now when you cease to practice and you can go get the renewal license at your pleasure of determination, but are you exposed to a penalty also?
No, so you're not, my understanding, you're not exposed to a penalty unless you are practicing as a teacher. And in my mind, the practicing as a teacher, I take it for the literal meaning. If you are actively doing the verb, you are in the practice of teaching, right? Outside of that, so again, I am an attorney at law, right? I can decide not to be certified, not to get my legal certification next year. I'm still a lawyer, but unless I take a matter from you, Kavan, then I really won't be in contravention, right? So there is a distinction. So if the teacher is without a license, and that's why they use the word practice, and the teacher does not go into the classroom and are involved. Let us say the teacher is without a license and goes into a different profession, then that's fine. But if the teacher is going to be involved in the practice of teaching, then the teacher has to be licensed to so do. And again, there are administrative things that can be put in place, but I'm not sure how we would find a way to capture that teacher who does not go out to renew, or for whatever reason does not renew their license. I think, again, we just have to appreciate that the scheme of the act is to say everybody in our classroom should either be a licensed teacher or has been assigned as an instructor according to the Act, right? An instructor gives us a wide array of people. But the reality is that if the license has expired and you do not have a license, then you can't be involved in the practice of teaching until you get that license. And again, if you know your license is going to expire, you would expect that the council would put in place provisions so that people can have their license. If the council appreciates that the person might not be able to have their license time period, a point I was like, there are things you can do administratively, but it has to be an offense if that's the scheme of the Act, quite frankly.
Remember, as you go and represent that person who would have been exposed with the 500,000 penalty or the conviction later on. So I'm just assisting you with arguments.
Well, I appreciate that. And I do believe in a tiered approach, and I do believe that we may want to look at the penalty. But again, why it's so broad-based is that, what I would say, I do take a tiered approach, and I believe that once fraud is included, it cannot be the same as an offense without fraudulent intent in terms of the penalty, right? But again, the scheme is very near to what is done for the legal profession. And I think that is the case because lawyers are critical and people repose a lot of trust and confidence in their attorneys to be competent to treat their matters. And it's the same for teachers, right? They are treated with the most vulnerable among our society.
Chairman,
go ahead.
I just want to put a scenario to my Manu friend. Let's take a crisis. A teacher of physics died, but there's a retired teacher of physics. We're coming up to exams, but because teachers retired and the license expired, are we now precluded from calling upon that retired teacher with all 30 years of experience to say, all right, in the best interest of the students, no teaching. It's now February, exam in May, no teaching in the best interest of the students. Because I'm not so sure that would be in the best interest of the student. So do we say for a teacher, an experienced and retired teacher like that she's in breach and we sanction such a teacher? In other words, is there some room for flexibility? I mean, I see recently with the exodus of teachers, we're saying let's call in some other people who are in teachers' college.
Yeah.
So I'm trying to say, is there room for flexibility and can we put that into the legislation?
What I would say, Member Brown and my new counterpart, what I would expect is that the teaching council would, in those circumstances, have an expedited process for that retired teacher to be licensed, right? That would be administrative. So what I would expect is that there must be a way, in an instance like that, retired teacher with a vast amount of experience, years of service to the profession, physics teacher has passed away, need a teacher for exam, the school would be able to reach out to the teaching council and indicate that this is the scenario and that they urgently need a license for this person who either had a license before or wasn't a part of the scheme, so never had a license, but was teaching for 30 years. So I would expect the council would have an expedited process so that that teacher could get in the classroom urgently, right? I don't believe that, I don't think we can legislate for those things, right? The council would have to design a scheme for situations of that nature so that you can quickly call up the thing, have the person apply, they get a license, and they can start teaching.
I agreed with that wholeheartedly, Chair.
Yeah.
I agree because we cannot legislate something like that. It's impossible. We're going down a slippery slope.
I want to call to the attention of members that proposed revision from the Jamaica Teachers Association is a fine of $200,000 for teaching without a license and employing a person to teach without a license. So that would rope in the employer, Member Gale. I think you wanted to have that addressed.
Before Member
well.
Gale answer that, Mr. I understand the JTA to be saying up to 200,000. It's not captured here as to the up to, but I understand. Because the 500,000 is up to, the judge could make it a lower fine. And I assume that anything would put in, and I accept the JTA recommendation of 200,000. It would be up to 200,000, would be my approach.
I don't see that up to in this.
Yeah, the up to, what he's saying is that the up to is not in there, but that is a determinant by the judge. And so the writing should prescribe the up to, that the judge can determine. The judge can say 150, 100, 200. It is at the discretion of the judge. That's what it means by having it written up to. But then I asked the question, and I have to put an obligation now on the employer to be satisfied that you're not employing a person that the legislation is clear on in terms of their right to practice. And should the penalty of the person that we are saying here up to 200 be the same for the employer? I believe, Chair, that the employer has an obligation to ensure that you don't employ nobody. You must go through the satisfaction. It's a requirement for employment for you to have that license. And so it ought not to be the same in terms of the amount.
Madam Chair?
I'm saying higher for the employer.
Madam Chair?
Member Rodriguez.
Yes, I want to wholeheartedly support what Minister Green had said before. So I'm in support of the tiered approach, and I'm in support of all that he has said, basically. And I also want to lend my support to what Member Gale, Senator Gale, just said. I believe the penalty for the employer should be greater, because employers, principals, heads of educational institutions need to take a greater responsibility for who they have in front of our children in the classrooms.
Chair, on the question of the employer, the definition currently on page 4, employer in relation to a teacher or instructor means a person who engages, employs, appoints, or has the authority to direct a teacher or the instructor to teach or practice as a teacher, as the case may be under this Act. Now, who does that cover? The board, the ultimate employer, the ministry or Ministry of Education, the principal, because that could be a source of who is exposed here. And I don't know if the Education Act provides any protection for people who have acted in good faith, like the board. So is this the board chairman? Is it the whole board?
You will be getting a certificate, something. You'll be getting some document to say that you're licensed. Or they could, what I'm sorry if I missed.
What I'm saying, okay. Mister, if we're going at the employers, my mind isn't made up yet as to how we include them. Who, in the case of the teacher at Mona High, who is the employer? Is it the principal who directs the teacher? Is it the board? Is it the board chairman? Is it the Ministry of Education? And I'm not sure if we include employers that we will capture exactly who signs the letter. So that's an issue that I think would need just some clarity.
Maybe, Chair, we can get clarity on who
is the employer.
Who does the engagement know? Is it the principal who engages?
The board. The board. Yes. Ms. Gordon? Anastasia? Yeah, under the current Education Act, who is the employer?
It's the board of management of the school.
So they will have an obligation to ensure that they are not
necessary
hiring
due diligence.
persons without
Yes,
license.
Minister.
Yeah.
The board of management. So the first line of exposure to process would be who? In other words, administratively, who engages with that teacher to accept and to receive the credentials? I'm understanding by what you have suggested in that it is the board who has final responsibility. But in terms of the exposure to accepting and receiving the credentials, I have to start there. Because somebody going to point finger, you know.
It wasn't me.
Somebody is going to point finger.
But Member Gale, at the end of the day, though, somebody has to say yes or no, right? Ultimately, right?
I'm just asking, you know, Chair, in terms of process, because I want to understand. I'm hearing today that it's a board of management. So by that, I'm accepting that the final responsibility rests with the board of management.
But can I ask a question, Madam Chair? What happens in situations where we're dealing with human beings now, where the board tends to rubber stamp what the principal says, which I think is what Member Gale is implying or wondering about.
But in
because
this instance,
there are instances.
In this instance, though, Member Rodriguez, the board is going to have to certify, and that should not be difficult, because you can call the Jamaica Teaching Council to find out if this teacher is duly licensed or duly registered. Right? It's not as if you have to go do, search and employ professionals to do a search. The Jamaica Teaching Council is the authority on whether a teacher is licensed or not. And
agreed, Minister.
Is there ever a situation where a teacher is engaged at a school without the knowledge of the board? It can never happen?
I can't say can't.
And that, Member Hamilton, is what I'm referring to, where the board, after the fact, sometimes may go in and ratify something that the principal did. But what Minister is saying is that no, boards will have to take responsibility for it from the beginning. They will have to be actively involved in the process and not just rubber stamp something. So this in itself is a good thing.
I'm also saying, Member Rodriguez, it will not be an onerous task on boards to determine if the person they're about to give a contract to is a licensed teacher or not. It won't be onerous. You simply need to be in touch with the entity that does the licensing to prove, right, that the person is a licensed teacher. It's not, you don't have to go hire detectives to find that out.
I don't think that's, well, for me, that's really not an issue, Chair, because as I said, that can be ascertained, but I'm thinking about those situations where, because, no, there may be scenarios where things happen in a school that a board is not aware of. In a situation like that, do we still hold the board accountable if they had no knowledge of it? I am looking at it from a perspective of a board for an entity. I've sat on other boards, and there are instances where the head or some other person of an entity will make decisions without the knowledge of the board. It happens. right?
So, member, in those instances, and I know, you know, in the private sector, let's say you are the head of a, you know, multi-billion-dollar corporation. Of course, you're not going to be knowledgeable of all the decisions in that corporation, but you get attestations, is that what it's called? You get the people lower down to sign off to say this is true and correct. I mean, I think it can be dealt with. I think the board can ask the principal whenever there is a board meeting, can you verify that all the teachers in this school are licensed? And you can have a principal sign off on that.
I'm talking about the initial engagement now.
Right, I know, but that there must be a way that the board, the teacher, I understand you to be saying the teacher is engaged by other,
the principal.
The principal. The board knows nothing about it, but I'm saying at a board, that something should be put in place that says to the principal, please verify that all the teachers that we have are licensed, and the principal maybe have to sign something to say yes, they're licensed or not.
So the renewal, so this demand is a new demand. The Board of Management would not have gone through this before. What we're now saying is that there ought to be some sort of a process that a list would have to come before the Board of Management to certify that the teachers are in compliance with what the legislation is calling for in terms of licensing. And it may come at various different times because all teachers' renewal period might not be the same. But it calls for an obligation now on the part of the Board of Management of each institution to ensure that there is this certified list of teachers in compliance with the requirement of the legislation.
Minister, I don't have a difficulty with the board having responsibility. Right now, if there's a contract awarded, the board has to report. Above a certain level, the board has to report. The board ought to know. The issue I have is it the chairman? Is it the entire board who is going to be prosecuted? Secondly, what happens now in a private company? Who is responsible? In a recent case handed down on Friday, that act, the NHT Act, required that somebody be assigned. We may not be going that direction in this legislation, but who is culpable? Is it the chairman? Is it all the members of the board? Is it a subcommittee of the board which might have approved it? And in the end, Minister, it is your budget, I take it, that is going to be paying the fine, and not the principal or board chairman or board. So I'm not yet moved to the position about the employers in this, because I think it has a lot of ramification which we need to work through. But for now, I'd love to hear, had this been Lambert Brown and Company with my board of directors, who would be responsible for the breach?
What do you mean if you're a private member? What do you mean if you're a private, if you're a private entity?
Well, let's take an independent school, for example, which would be a private entity. Let's take Grace. Dan is not here, so I'm inquiring. Let's take Grace. Who would be responsible for such a... Who would be responsible for such a breach? The managing director? Board of directors? So if we include that, it would need to be clear as to who. And then in many cases I've seen where boards are indemnified, where they have acted in good faith so that they can be sued and and the fine, because the little that is paid, Senator Gale, to board membership, I think it would be unfair to ask them to be paying
To expose themselves
to this. So we need to look at it, and I'm not sure if administratively I am with including the employer in this situation yet. But I can be persuaded.
But Chair, I'd like to.
Go ahead, Member Green.
Anytime I feel like I'm agreeing with Member Brown, I worry, but I have to intervene when I am. So, you know, when this came forward, Chair, I did sit in the committee saying that this was very novel. I don't know if you've had any bills where the responsibility is placed on both the employee and the employer to protect the scheme. In other words, what you're trying to do is to ensure that you don't have isolations, unlike teachers in the classroom, and you put responsibility on the person who is going into the classroom to be licensed, and you make it a criminal offense, and then you put a responsibility on the employer who is taking the person in the classroom and make it a criminal offense as well. So it's very novel, but it may be impractical, and impractical for some of the reasons that Senator Brown outlined in relation to who is the employer of the teacher, especially in the public setting. Is it really the board? Clearly the board conducts the employment process, but the public teacher is paid for by the government, Ministry of Education. Who is really, the question will be asked, who is really the employer? And there might be a lot of challenge in trying to make the employer the person who is culpable and liable in circumstances where an unlicensed teacher is in the classroom. You know, most of these schemes, the responsibility rests on the person who is in the profession, entering the profession, to ensure that they comply with the standards and requirements of the profession. So again, I use these examples a lot because the scheme is not very different, but there is no responsibility on the client to ensure that their lawyer is duly certified, while it would be their best interest to do so. But it is not an offense if they took a lawyer and took that lawyer to court, not that, but it would be an offense for the lawyer. So I too, like Senator Brown, I'm not convinced. I see that it is a novel approach. I see it would put in a double layer, but I'm not convinced that the impracticality of it does not outweigh the sort of plus that it may bring to the scheme of things. Thank you, Chair.
Any other comments on this from members? So I
Sure,
think
this is one of them that I believe at this stage, in treating with the employer, that we may have to put in a parking lot and come back to it and give ourselves some time to think about it.
All right, so in terms of the recommendations from the Jamaica Teachers Association with regards to whether or not an employer is penalized for hiring someone who is not registered or licensed, we will put that in the parking lot, as Member Gale said, in terms of just allowing some time for reconsideration, for us to consider again that. With regards to the other recommendations of making a tiered approach to the penalties, I believe we accept that. I believe all of us accept the tiered approach to the penalties.
That's correct.
And that it would be, whatever the penalty is, the wording should be up to whatever we decide on in terms of those final numbers.
Correct.
I think we all agree as well that for fraudulent cases, the penalty should be the maximum. And
no, you mean the penalty should be higher?
Should be higher.
Yeah.
The penalty should be higher for fraudulent cases. All right, but we haven't yet decided on what the penalty would be.
Madam Chair, just to clarify, whenever there is a penalty specified, it goes without saying that that is the maximum. So we don't have to say up to so and so. It is taken that is the maximum that the court will go, and then the judge has a discretion as to what fine to give up to the amount that is the figure that is stated in the law.
The language we're saying, it is not a fixed fine.
Excuse me, members. Excuse me.
It's not a fixed fine.
Member Brown. It looks like we do not have a quorum, and so we may have to stop here. But we do have some topics to think on and come back for the next meeting. And we know what these are in terms of practice as a teacher versus teach, educational setting versus educational institution, para-tutor.
I am taking it, Minister, that it hasn't been brought to your attention about the quorum, which will allow us to continue.
No, it was brought to it has been brought to my attention. Yes. So, sorry, let me take a roll call online. Member Green?
Ever present at that time.
Okay. Member Crawford? Member Rodriguez? Okay. Member Miller? Okay. All right. And Member Hamilton had indicated that she would have to leave. Okay. All right. So, but we do have things to to think about and come back for the next meeting. But we are agreed, though, out of this meeting that there should be a tiered approach and that the penalty for fraud should be higher. But we haven't yet agreed what those penalties should be.
Before we break, Chair, the Teachers' Council mentioned the Nigeria legislation, and it addressed the issue we were discussing earlier. Is it possible for your technical people just to pull the relevant section of the Nigerian legislation and share with us before the next meeting?
All right. Mr. Nash, legal team, you're making a note of that? All right, or any other from a Commonwealth jurisdiction. All right. Okay. So for the next meeting, we will resume on clause 24 and pick up on those matters. In terms of future meetings, We have two suggested dates: Thursday, October 6, 2022 at 10 a.m. and Tuesday, October 25th, 2022 at 10 a.m. Thursday, October 6, Tuesday, October 25, but I'm asking Mr. Nash if we do not have any other dates, I mean, between the 6th and the 25th. All right, he will look at other dates between the 6th and the 25th. But the next meeting is Thursday, October 6th, 2022 at 10 a.m. And our meetings will continue to be hybrid.
Chairman, as to this meeting, we are adjourning because there's a motion for adjournment. I hate to say we are adjourning because of lack of quorum, because I don't want people to pick up and say we had no quorum, because Minister Green is still with us, and there's a difference when we adjourn on our own steam. As against it has been said that we couldn't find a quorum.
And I am still here, Chair.
Okay. All right, so we're good. Thank you, Member Hamilton. All right, we're good. Half an hour to 4:30. Yeah. All right, so Member Brown, you were making a point?
No, I was...
On the Nigeria.
Yeah, I'd
Council of Nigeria.
Yeah, I'd just ask if the technical team could pull that section of the Nigerian legislation and share with us. So at least we could have sight of something else and so forth, yeah.
Okay, I agree.
And my suggestion earlier, Minister, wasn't that this is not a convenient time. I just wanted to be clear that it is a convenient time, given where we have to go next, but we are in quorum, is the point I was making.
All right, so then, all right, so we're dealing with the Teachers Colleges of Jamaica in terms of the Council of Nigeria Act. So we'll get that before the next meeting. Could we move over to the University of Technology? Their observation, concern, query, also in relation to Section 24.1. And it says, we acknowledge that the stipulation is necessary for the upgrading of the teaching profession, but questions what provisions have been contemplated for the possible teacher shortage in some subject areas like mathematics and the sciences, which this provision will most likely exacerbate, set against the background of teacher migration and a presumed shortage of qualified STEM teachers. Wasn't quite sure what they meant by that. I don't know if any members have any observations, because
I understand this clause, Chairman, through you, that they're saying flexibility. We want, and they want the standards to be set. But there could be in a nation temporary situation which requires to be not as rigid, and they're identifying particular areas. I guess those areas may not be limited. So it is for us to give some thought to, is there a way to allow for, quote unquote, an emergency, a crisis that allows to shift a little from a, want of a better word, a dogmatic position in the legislation. So it is giving thought to temporary situation that I read them to be saying.
Right. But I go back to what I think a member suggested, that I think it was Member Green, that in some situations you could have expedited processes to deal with emergency situations of licensing. Member Hamilton suggested that you could have expedited processes.
Yes, Chair.
Yeah.
I was just about to come in and say that that would be an administrative procedure, which we wouldn't need to legislate on. In a situation like that, the council would be able to act quickly. So I don't see the need for us to put that in our legislation.
Maybe through you, Chair, the legislation can allow for, just as you have emergency passport, maybe it can allow for emergency licensing for a temporary period, because I'm not so sure what is going to be the length of the license. 5 years, 3 years, 5 years? So maybe there can be short-term licensing, and we could put that in the legislation, which allow the council to act with expedition and not necessarily give somebody a 5-year license when the circumstances really require 6 months or a school year and most. So,
Dr. Gordon, any thoughts on that? Or this is something you want to give some thought to before you respond?
Yes,
you want
Chair.
to give some thought?
In situations like those mentioned, there has to be some administrative consideration. So if a short-term license is required or authorization to teach, the council should be in a position to grant such permissions.
And we should give them that power in law.
That's the point, where the council now would have that authority to do so, rather than prescribe the specific terms. Give the council the authority under these circumstances where it's able to allow for these modifications. Because what they are citing here may be a situation that may arise and calls for the level of flexibility that is required.
Mr. Chair, in the area that Senator Gale and I practices on a day-to-day basis, we have seen our lawyers, sorry Floyd and Tova, but we have seen our lawyers creatively try to raise issues to put obstacles in the path of just resolutions to disputes. And we don't want some smart lawyer to be challenging this. So if the power is in the council, and it is for the council to decide when and how it uses it, but we want to protect the council when it does that.
My McFly now calls for our practicing to be under a license of some sort, whilst we are registered as trade unions.
All right, thank you, members. And we will complete on page this last recommendation for from the National Parent Teachers Association of Jamaica in relation to Section 24. They believe the fine of $500,000 is too low to act as any form of deterrent, and that this should be raised to at least $2.5 million for it to make sense. And their rationale is that in other jurisdictions, anyone convicted of practicing without a license faces a range of penalties. These range from fines, incarceration, probation, to restitution. If someone is convicted of practicing a profession without a license, they will likely face a fine. The size of the fine depends on the kind of activity in which they are engaged. So, they are asking us to consider an increase in the fine.
I'd like to say I respectfully decline their desire, unless they expect inflation to run away. A teacher earning whatever the new rate is going to be, and somebody pretending to be a teacher, right? Cool. And until we change the other part of the legislation, I couldn't support such levels of fine.
Not even for the fraudulent
For the
Bandula
Bandula?
case?
I was moved by the extremism of 2.5 million.
So, in other legislation where a person would have demonstrated fraudulent action, is that penalty similar to what this is proposing? 2.5 million? Because we have to take that into consideration, whether or not in other legislations a penalty, this 2.5 may be exceeding what another fraudulent act might have been in another legislation. And I'm one who supports a level of consistency in this case.
So I know Ms. Gordon can look at ours, the fines and penalties at the Ministry of Education, because we went through a review of those. So she could give us a sense of whether or not it aligns or it's way off the mark.
Minister, to just indicate, for example, under the Legal Profession Act, their penalty is $500, not exceeding $500,000, or imprisonment of 12 months, or both such fine and imprisonment.
And that's which one?
Legal profession.
Legal profession.
But we will definitely look back to see if what would be reasonable in terms of the fraudulent provisions, and get back to the committee with the other section 24.
Through your chair, could you just look at the other councils, the nursing, the medical profession, and so engineering?
I think that would be very helpful. Okay. So committee members, we're going to pause here. There are several questions that the legal team will look at and come back to us on section 24, which we will continue at our next meeting. And if we get through that, then we will be into section 25.
October 6th, Minister. October 6th.
Yes. October 6th
Yes.
at 10 a.m. Okay. All right. The following sections, 25 and 26, they also deal with penalties. The offense of pretending to be a registered teacher, licensed teacher, and the offense involving fraud and misrepresentation. Right? Okay. So 24, 25, 26. Yeah. Mm-hmm. Okay. All right. Are there any questions from the legal team? Anything that you're not quite sure of just yet in terms of the requests and the questions that members have?
Yes, Minister. Just I seek a little clarity in terms of the proposed tier approach. What exactly is meant? The tier approach in terms of the penalties or any penalty for clause 24. When we say the tier, apply the tier approach, could I get a little clarity on that?
Through your chair. My understanding is it's two different offenses. The offense of fraud and the offense of non-renewal, to make it two different offenses.
I assume what you're saying, because we already made a distinction in terms of fraudulent act, and there's no tiered penalty where that is concerned. But in terms of the non-renewal now, there needs to be some clarity if we are proposing a tiered penalty. My assumption of tiered penalty in this case might be first offense X. If there's a second offense, X plus Y. That's my only thinking in terms of a tiered penalty, because it's just clear whether or not you are not renewed, and if that non-renewal imposes a penalty. And in my mind, any tiered approach would be first offense, second offense, how you are treated. That's my thinking in that regard.
All right. So there's much to contemplate. Thank you, members. We are going to pause here. We've given you the future hybrid meeting dates, and I'll just repeat them. Thursday, October 6, 2022 at 10 a.m. Tuesday, October 25th, 2022 at 10 a.m. And Mr. Nash is going to see if there are other dates in between, because we would love to continue. We'd love to wrap this up. We've been at this since February of this year, so we'd love to go through the process. All right. Is there any other business?
If there's none, I move for the adjournment.
So adjourned. Second? All right. Thank you so much. Thank you, members. Thank you to the legal team. Thank you to, I know we have our legal team online as well. Thank you so much. We will see you at the next meeting. Thank you, everyone.